An employee lifts a heavy crate, tears a muscle in their lower back, and files a workers' compensation claim. The employer approves the claim, covers the medical bills, and assumes their legal duty for the incident is completely fulfilled. Months later, that same employer is hit with unexpected six-figure federal safety penalties for failing to properly document that exact same injury. This happens because workers' compensation and OSHA record-keeping operate as distinct, non-overlapping legal regimes. Compliance with one does not equal compliance with the other. Workers' compensation is a state-level insurance system. Its exclusive functions are to provide wage recovery for the injured worker, pay for medical care, and mitigate civil liability for the employer. OSHA's 29 CFR 1904 standard is entirely different. It is a federal data gathering system. Its purpose is to track national injury trends and identify active workplace hazards, regardless of who is at fault. Because these systems run on parallel tracks, a single mechanical event can trigger one system, both systems, or neither. This map illustrates the structural gap. Workers' compensation consists of 50 highly variable state statutes, each with their own definitions and thresholds. OSHA enforces a single, identical federal requirement across all 50 states. Treating state insurance compliance as proof of federal safety compliance creates immediate, hidden legal and financial exposure. The divergence begins with how each system determines if an incident is actually work-related. Workers' compensation relies on a standard of increased risk, or arising out of employment. The claimant must prove that the specific duties of the job directly caused the harm. OSHA uses a rigid positional risk standard. Positional risk is a geographic presumption. If an injury or illness occurs within the physical work environment, OSHA automatically presumes it is work-related. Under federal regulations, the work environment is defined broadly. It includes the physical building, the parking lot, and any equipment or materials used by the employee during their shift. This geographic presumption stands even if the employee's work was only one of many contributing factors to the resulting injury. A single incident is judged by entirely different metrics. The state evaluates fault and liability. The federal government evaluates location and environment. This disconnect creates 7 common points of failure for employers. The first is the assumption that a denied workers' compensation claim means the injury is excluded from the OSHA lock. Consider an employee who injures their shoulder on the warehouse floor. The insurance carrier reviews the file and denies the claim, citing a pre-existing tear. OSHA requires you to record the incident if the work environment significantly aggravated that pre-existing condition, regardless of the carrier's denial. The second point of failure centers on injury severity, specifically the confusion between first aid and medical treatment. OSHA defines first aid through an exclusive 14-item list. If a treatment is not explicitly on that list, OSHA automatically classifies it as medical treatment beyond first aid. Interventions like sutures, rigid splints, or prescription medications require immediate entry on the OSHA log. Administering even a single dose of prescription medication to an injured employee crosses the threshold into medical treatment. Provider credentials do not alter this classification. A licensed physician can administer simple first aid, and a layperson on the shop floor can administer medical treatment. The action dictates the recordability, not the title of the person performing it. Misclassifying a single medical intervention because you relied on assumptions rather than the 14-item list puts the organization out of compliance with federal law. The third failure point is the belief that accommodating an injured worker with light duty voids the recordable penalty. If a doctor restricts an employee from heavy lifting, the employer will often move them to desk duty and assume the incident is now a non-recordable minor event. OSHA evaluates these accommodations against an employee's routine functions. These are work activities the employee regularly performs at least once per week. If an accommodation restricts even one routine function, you must record it as a job transfer or restricted duty case. For record-keeping purposes, OSHA caps the tracking of lost or restricted days at a maximum of 180 days per case. The fourth point of failure is the 7-calendar-day trap. Employers frequently wait weeks for a workers' compensation carrier to accept or deny liability before logging the incident in their safety records. OSHA dictates an absolute timeline. Employers must enter the case on the 300 log within exactly 7 calendar days of learning a recordable event occurred. Workers' compensation moves at the deliberate speed of civil litigation. OSHA operates on a rigid, rapid deadline. To navigate this, employers must use the line-out rule. You make a good faith entry immediately based on available facts. If new information proves the case was not recordable, you cross it out later. Federal compliance relies on speed. Linking your OSHA entries to the slower insurance process guarantees systemic violations. The fifth failure point involves confusing routine injury logging with severe injury reporting. Simply placing a severe injury on the 300 log does not satisfy OSHA's requirement for immediate direct notification. This timeline tracks the federal reporting windows. If an incident results in a fatality, you must directly report it to OSHA within 8 hours. Inpatient hospitalizations, amputations, or the loss of an eye require direct reporting within 24 hours. The sixth point of failure is treating the OSHA 300A annual summary as a private corporate document stored away in the Human Resources Department. The 300A summary must be publicly posted in a highly visible area where all employees can review the data. The mandatory posting window is exact, February 1st through April 30th of the year following the records. The final point of failure is mishandling privacy cases and exposing sensitive medical data on those public-facing logs. Specific injuries require strict privacy protection. This includes needle sticks, injuries to intimate body parts, sexual assaults, and documented mental illness. For these incidents, the employer must write the words "privacy case" in the name column instead of entering the employee's actual name. Transparency and public visibility are core requirements of OSHA's federal mandate, which stands in sharp contrast to the strict medical confidentiality required during insurance claims. Misclassifying a single mechanical event causes damage across two separate fronts simultaneously, resulting in a double penalty. This chart stacks the financial impact. First, workers' comp claims compound base medical costs and spike your EMOD rate, destroying contract bids. Second, failing to properly document cases adds six-figure OSHA fines directly on top of insurance costs. To correct this, implement a survival checklist. Phase 1. Deploy an immediate incident intake form, train your supervisors on OSHA's recordable triggers, and assign a single point of contact for all classification decisions. Phase 2. Automate 7-day calendar reminders for log entries, centralize clinical documentation, and establish automated alerts for the 8-hour and 24-hour severe reporting windows. Phase 3. Audit all incoming clinic invoices against OSHA's 14-point first aid list, conduct quarterly log reviews, and physically separate your workers' compensation files from your OSHA compliance files. Pull the files for your organization's last 10 workplace injuries and audit them strictly against these federal criteria tonight. Permanently decoupling these two systems in your daily practice is the only way to protect your organization from catastrophic regulatory and financial exposure. Subscribe to HSE Study for more insights on mastering workplace safety regulations.